Mayor Panko, we're on.
Okay, good morning, everyone. Great to have the opportunity to connect with you today. I'm Sean Panko, Mayor of Smith Falls, and with me today we have Linda Tranter from the Legal Clinic in Perth. And almost half our citizens in Smith Falls rent their homes, and we recognize that there's a risk and a responsibility that comes with renting your home, and we want to ensure that everyone understands their rights, their responsibilities, to help ensure, obviously, that you have a chance to keep the home that you're in today and the home that you enjoy the most. Whether you're a landlord is a tenant, sorry, is an individual or a large corporation, the relationship is governed by the Residential Tenancies Act of Ontario. The act sets out the responsibilities of both tenants and landlords, including a framework for rent regulation and increases. It's also the province that governs the Landlord and Tenant Board, which is a tribunal that exists to resolve disputes between landlords and tenants. It's the only authority that can impose an eviction. So understanding many of our tenants in recent years have faced wrongful evictions. The town's Housing Advisory Committee a few years ago ran a tenant workshop like this with Linda. We decided, it's been a few years since that was done, and we want to ensure that our citizens, again, understand their responsibilities and their responsibilities and also the right, and ensure that the better probability you understand your rights. If you're facing a wrongful eviction, facing the risk of losing your home, you're in a much better position to ensure you can stay housed. So with that, I'm going to introduce Linda Tranter. The Legal Clinic in Perth provides free legal services for low-income residents in Lanark, Leith, Grenville, parts of Frontenac, Lanark, and counties. Provides representation and advice on a number of legal issues. Today, we're very pleased to have Linda here. I've used Linda as a resource countless times over the years. Anytime someone has contacted me who is facing a wrongful eviction, Linda stepped up and in almost all cases is able to help make a difference. So, Linda, I won't speak anymore. I'll turn it over to you and let you carry on the show.
Great. Thank you so much, Mayor Panko, and thank you to Town of Smith Falls for always being a great advocate for our tenants. It's been a real pleasure to work together to support the folks in our community. So today, the focus of my presentation is going to be on some recent changes. I will have general comments about the protections that are still in the Residential Tenancies Act, and that's what the law is called. But I was asked to talk about the new Bill 60 that's recently become law. Now, I'm assuming everybody can see this slide there, removing tenant protections. I'm certainly going to say that this act doesn't remove most tenant protections. So we're going to talk about that. It's a little bit of a chipping away. So as Mayor Panko said, my name is Linda Tranter. I'm a staff lawyer at your local community legal clinic. Every community, every county, and every city in Ontario has a free community legal clinic that gives advice to tenants and also, but not landlords. There is a free service for landlords called the Landlord Self-Help Center, also governed by Legal Aid Ontario. But my role is to work to protect tenants. That's what we're going to talk a little bit about today. So I'll have you advance to the next slide, please. Okay, just quickly, the legal clinic serves as Mayor Panko said, Lanark, Leith, Grenville, North and Central Frontenac, and Attic Islands. We are a group of 9 lawyers, 2 paralegals, 3 support staff, and we're 100% funded by Legal Aid Ontario. All our services are free. You do not have to be a low-income person to get some basic advice, but you would have to be a low-income person for full representation at a tribunal or a board. But do not hesitate if you are a tenant to call us for legal advice if you are in our region. If you are not in our region, we'll be happy to refer you to your local community legal clinic. So next slide, please. There's some confusion about what legal clinics do, so I'll be brief. We are not Legal Aid Ontario. We're a separate, independent nonprofit organizations funded by Legal Aid Ontario, providing direct service. You don't have to fill out a legal aid form to use our service, but we are limited in what we can do. We do not do family law, children's aid, criminal, real estate, or civil litigation in the Superior Court. A Legal Aid Ontario will provide free representation for folks that have family, children's aid, or criminal matters who are low income. Phone numbers on the screen. What do? We protect basic minimum incomes like ODSP, Canada Pension, Ontario Old Age Security, Ontario Works, child tax benefits. We provide advice for tenants about housing law. We also provide representation in many cases. We provide advice about employment for employees, not employers, and we assist with employment insurance issues or denials. We do workers' compensation work. We represent people before the Workplace Safety Insurance Commission. We also do some wills and powers of attorney only for low-income people, and we give some general advice around health and disability rights, debts, consumer rights, contracts, things like that for low-income people only. Okay. Next slide, please. Sorry. So a new bill has been passed. It's called Bill 60. The official name of the bill is Fighting Delays and Building Faster Act of 2025. There's a quick summary there, but I'm going to talk about the bill today, but I'm also going to give folks some reassurance. This bill is not gutting tenants' rights. It is tinkering with tenants' rights. It's some very minor changes, and we'll talk about that. And the bill primarily deals with development, building, a lot of issues, development of housing, that sort of thing. I'm not going to talk about that today, not my area of expertise. But for some reason, there was some minor tinkering with the Tenants' Rights and Residential Tenancies Act in the bill. And it's a bit of a mystery as to why, because it doesn't seem to bear any connection to the building of new housing. But we'll talk about that as we go. Next page, please. So before we get into the details of Bill 60, I want to give everybody some reassurance. There's been a lot of panic around this bill. One of the reasons for the panic was initially when they drafted the bill, there was a section that said that they would remove a landlord's right or a landlord's ability, or sorry, they would remove the requirement of just cause or a good reason for eviction from the Residential Tenancies Act. Basically, in other words, when they first came out with the bill, they said that we're going to give landlords a right to remove tenants for no reason. That section of the act was very quickly dropped. That is definitely not what the act looks like now. The fundamental rights of tenants are still in place. And here's a quick summary of some of those rights. You certainly have, as a tenant, you have a right to a safe home with adequate heat, hydro, water, timely repairs. You always have that right. Even if your tenancy agreement said that you took the home as is, your landlord said, well, just so you know, there's a leak, nothing I can do about it. The law says that you always have the right to a safe, repaired home. There are resources in place to assist you. And we can talk about that. One of them is calling your local municipality for an inspection. Another one is filing with the landlord and tenant board. Obviously, you wouldn't want to do either of those before writing to your landlord and making a good basic request, preferably in writing. Yeah, another basic right tenants have is not to have their rent increased more than once every 12 months with 90 days written notice to the maximum set by the government. That's 2.1% for 2026. There are some exceptions to the rent increase rules. I'm not going to get into those today. If your landlord says you're not covered by rent increase rules, then you can certainly call us and we'll check and see if that's true. Rent geared to income is an obvious one. You wouldn't receive a rent increase unless you receive an income an income increase. And so that's a completely different system based on how much income you have. But the majority of tenancies in Ontario and certainly in our area are covered by the maximum rent rules. You certainly have a right to privacy. Landlords have to give you 24 hours notice of entry with a reason and a time, except in emergencies. Emergencies like a flood or a fire. And then they should give you as much notice as reasonable or possible. Tenants have, no, here's the big one. Tenants have a right to be protected from eviction. There must be grounds, a specific reason for eviction. There must be a legal notice on a proper form, not just an email, not just a letter. There must be an application to the landlord tenant board, and there must be a hearing. At that hearing, a tenant has a right to bring their issues and their dispute and have their case fully heard before the landlord and tenant board. Tenants have not lost that right. As I say, there's a few minor changes to the way that that's going to work, but they are not huge changes. I strongly recommend that if you do get an eviction notice, that you get legal advice right away, understand the process, understand the grounds. We can tell you whether or not the notice is a lawful notice. We can tell you whether or not it's filled out properly. We can certainly give you a good idea what to expect next, how to prepare, how to file any documents you might want the board to look at, etc. Best thing you can do is get legal advice early and often. If you get eviction notices, we're here, we're free, and always happy to talk to you. Press 0, you'll get right to an intake worker, or you can leave a message and someone will call you right back. Other basic rights, tenants always have a right to rent receipts. It's a legal right. You also have a right to pay however you choose, whether it be cash, e-transfer, checks, etc., depending on your circumstances. You do have a right to have a roommate or a family member live with you without permission, except if you're in rent-geared income housing, where financial disclosure rules do apply. That's more complicated, but you have that right. You don't need permission. You also have a right to have a pet or two, or possibly even 3, depending on your municipality. And you do not require your landlord's permission, even if your lease prohibits it, but you're responsible for the behavior of that pet at all times. Whether it's noisy or whether it bothers anyone, certainly don't want your dog biting anybody. You could lose your housing because you're responsible for the pet. Next thing is you're certainly protected from any form of, the law protects you from any form of discrimination. That doesn't mean it doesn't happen, of course, based on race, religion, age, family status, disability, and there's a variety of other grounds in the Human Rights Code. That means you can't be told you're too old or too young. You can't be told we don't take people on ODSP or Ontario Works. We can always happy to give you more advice about that. Also means that your landlord may be responsible to make changes to the way your unit is set up, your apartment is set up, or your home is set up, or changes to the way they deal with you if you have specific disability related needs. Finally, tenants have a right to bring a case to the landlord and tenant board for a violation of their rights. There are other rights, but these are the most fundamental rights as I see them, and I'm happy to talk a little more about that as we go. So this is to assure you that your most important rights are still in place. Next page, please. Okay, Bill 60. Bill 60 passed, became official law in November 2025. But all of the provisions in Bill 60, and frankly, there are only 8 of them, okay? There are 8 sections that apply to tenants. It's not that long. All of them require regulations and proclamations to be officially in force. None of them are in force yet. The Ontario government is in the process of doing some consultations, asking for feedback on what might be reasonable. And we have yet to kind of see the meat in the sandwich as to what the regulations will require. landlords and tenants going forward. First of all, we won't panic. Well, you're going to hear me keep saying that. None of this is actually enforced yet, so we're ahead of the game, which is great. Until these regulations and proclamations are come forward from the Ontario government, none of these rules will take effect. So, next page, please. So now what I'm going to do is go through each of the 8 changes and explain how they're going to affect tenants. And as I go, I'm going to tell you what happens now and what's going to change. So right now, if you get behind in your rent and you're a tenant, your landlord will give you a notice to end your tenancy for non-payment of rent. It's a first notice. It does have to be on an official form, and we often call it a warning notice, but it is a serious legal warning notice. According to the law right now, if you get a notice saying you're behind in your rent, you have 14 days to catch up on your rent before your landlord can apply to the landlord and tenant board. This Bill 60 is going to change that from 14 days to 7 days. Now, that doesn't mean you're evicted in 7 days. The next step after the 7 days is the landlord will apply to the landlord and tenant board. The case will get scheduled for a hearing. Right now, that's taking about 2 months, 1 to 2 months. Things have sped up a lot. At that hearing, you should appear. You can get assistance from us. We provide advice to all tenants, both before their hearing and also at the hearing through our Tenant Duty Council program. We provide representation to tenants who qualify and who contact us in a timely manner. Usually at the landlord and tenant board, we can assist you to negotiate a payment plan to catch up. So if you get one of these, so the change is that the warning period will go from 14 days to 7 days, and after that, the landlord can apply to the landlord tenant board. Eviction is not automatic, but you need to be very careful that you don't miss the hearing, or the eviction may end up being virtually automatic. If that happens to you, get legal advice right away. Contact your local community legal clinic. So that's change number 1. Page. I think a lot of people have heard of landlord own use notices. That means a landlord can give you 60 days notice saying that themselves, they personally, their parent, their spouse, or their child need to move into your apartment or your home and take it over. There's a small change happening to this, 2 small changes actually. One is that right now, they have 60 days. They have to pay 1 month's rent or offer you acceptable, suitable alternative accommodation. This is not your last month's rent. This is money to essentially help you to move, I would say. 1 month's rent, no strings attached. It's a requirement. This rule is going to change to give a landlord an option of giving you 120 days notice, that's 4 months, and no compensation check of 1 month's rent. Why they're doing this, not clear. But that's, I mean, the 120 days would certainly give a tenant an opportunity, a better opportunity to find a place. So, I would approve of that aspect of the change. I strongly recommend do get a notice saying landlord wants to move in. You contact legal advice immediately. Look, your local community legal clinic. In this case, that would be us. We're the only one for Lanark, Leeds, Grenville, Smiths Falls, etc. But if you're not in our area, then there's a local community legal clinic who can give you advice and help you navigate forward. You do not have to move out just because the 60-day notice on 1 month. Next screen. Tenant issues. So again, this is a bit of an obscure change. I'm super well aware of it. I've been a staff lawyer at the legal clinic, by the way, for 26 years. So I deal with these every single month, every single week. So when a landlord takes you to the landlord and tenant board for non-payment of rent, you have the right under the law to bring your reasons and your complaints forward by way of response. A couple pictures there. On the left, you got somebody with no heat. I can't quite read it. It's not too large. And on the right, you got a property manager. It says property manager didn't take my bed bug seriously. Sometimes tenants stop paying rent because their living situation is so severe that they feel it's unfair. Sometimes tenants stop paying rent because they end up having to pay other bills, move to a motel because there's no heat, the roof is caving in, some bad things can happen. My advice to you is always pay your rent. Get advice. Get your advice early when there's a serious problem. Get the problem addressed. Don't stop paying your rent. But this change, Bill 60, is going to provide that a tenant who is behind in the rent may have to pay 50% of the rent arrears claimed by the landlord before they can bring forward their own complaints and issues, their own defense, which is very concerning. I've certainly had situations where a tenant had to start paying some very unusual bills, like the heat or the electricity for the whole building because the landlord refused to do so. That's an extreme circumstance. Or I've had tenants who could not remain in their home and ended up having to move to a motel because situations were so bad that all of their money was going to alternative accommodation. But this change, once it takes effect, and it hasn't taken effect yet, it's going to mean that navigating really serious problems, lack of repair, maintenance, basic heat, hot water, power, it's going to be really, really important to get your legal advice early and not just stop paying your rent. Or we're going to see folks who have very serious maintenance or repair issues evicted before they have a chance to raise their concerns. That could happen. They're also looking at putting more rules about how to raise your issues, when to raise your issues, etc. And we have yet to see regulations on that, so we don't know what it's going to look like. So that's one change, and a concerning one. So next page, please. Okay, this is a pretty important right. If for some reason you miss your landlord and tenant board hearing, perhaps you didn't get a notice of hearing, perhaps you were looking after your sick mother, who knows? Maybe you don't have internet and you don't know how to use Zoom, and you certainly don't know how to use portals and all this other high-tech stuff that people are having to do. All landlord tenant board hearings at this point in time are online. My understanding is they have a rule that says you can request an in-person hearing. And in 2025, I believe the landlord and tenant board statistics show that they had one in all of Ontario. So your chances of getting an in-person hearing aren't great. But anyway, if you miss your hearing, or if you go to the hearing and things don't go well, you weren't allowed to raise your concerns, you feel that someone made a serious mistake, right now you have 30 days to request an appeal. It's called a review. You've got 30 days, and that's not 30 days from the date you get the decision. It's 30 days from the signature date on the decision. So you might not get it for a week or two, depending whether it comes by mail or there's delays. You can request an extension of time. This new bill is going to reduce your appeal period to 15 days. That's pretty serious. Means you're going to get a copy of the decision. Frankly, you want to get legal advice. If you don't draft your appeal properly, you will not get a new hearing. All of those appeals go in front of a member to decide whether or not you've raised serious reasons for a new hearing. And so you're going to have to get some legal advice. You're going to get a copy of that decision to someone, and then you might have to get the recording, and you're going to have to write something. You're probably going to need some help. You're going to have 15 days. Now, you can request an extension of time if circumstances if circumstances are such that it seems reasonable. Again, get legal advice. Not sure why they are reducing the time to appeal. This affects both landlords and tenants. And we don't know what the rules and conditions are going to be because regulations, again, don't exist yet. It is a concern. I would say to you, if you get a decision saying you've been evicted, as soon as you receive that decision, please get some legal advice. Even if it's over the 30 days or over the 15 days, get some legal advice. A lot of times we can assist you to get back in front of the landlord and tenant board and plead your case. Next page, please. Notices of termination. So I know this is, for those that don't know much about landlord-tenant law, this is perhaps very technical stuff. But the first stage, and everybody knows, I think, the first stage of a tenant being evicted or being asked to be evicted is to receive a legal notice that looks a little bit like the one on the screen there. It's usually about 2 or 3 pages, and it gives you the reasons. This is an odd amendment. This amendment simply says that instead of the landlord and tenant board fixing up or determining what the form should look like, and we've had a bunch of different versions of the form. There's big bold print saying this is an eviction, get some help now. There's things on those that are supposed to tell tenants what this is. But instead of the landlord tenant board drafting these forms and improving these forms, the Ontario government is now going to give that authority to the Ontario legislature, and the forms are going to be determined by the Ontario government instead of the landlord and tenant board. Not sure why that is. It certainly will slow down board's ability to receive feedback about problems with forms, things that are hard to read, things that are unclear. So again, we don't know what this is going to look like. It's not a huge problem. You're still probably going to get a good notice that tells you what the issues are and what you need to do about it. There's a certain amount of fine print. And if you do get one of those notices, please get legal advice immediately. Next page. I know I'm a broken record on that one. Persistent late payment. So this is something that most folks don't deal with very often, but we do. This is when your landlord's not saying that you're behind in your rent so much as saying that you're always late in your rent. And your lease will set out what date your rent is due. It's usually the 1st, but it's not always the 1st. It could be the 15th. It could be the 20th. Whatever is agreed when you sign that lease. And by the way, in Ontario, there is only one lawful lease for tenants. And that doesn't mean you're not a tenant. If you get handed a 2-page, handwritten lease, you're still a tenant. But that lease usually sets out all your rights and responsibilities. Anyway, if you don't pay your rent on the date that it's due, you could get an eviction notice, again, a warning notice, saying you've been persistently late. That's the first stage in a process of going to the landlord and tenant board. Obviously, you get a notice like that, start paying on time. Keep a record of what date you paid. Be very careful. If you're paying by e-transfer, some days you might send it on the Monday, but it won't get cashed until the Wednesday. That's true of checks as well. But keep track of how you paid and when you paid. Usually, if you go to a hearing on one of these, you're going to get a pay on time order, pay on time for a year, or receive an eviction order without another hearing. That is usually the outcome. You want to get some advice, though, to ensure that you understand and have an opportunity to participate. If you don't go to your hearing, you probably won't get a pay on time order. You may get an eviction order. So go to your hearings. If you need help, we can help you to do that. 60s to allow the Ontario government to make specific rules about when is too often if you're paying your rent late. We don't know what it's going to look like. But again, so it seems that the Ontario government, there's a trend here, wants to take back some of the humanitarian and basic human decency, take it out of the hands of the landlord and tenant board, and set out specific rules and regulations. Perhaps this could be helpful. At the same time, what it does is it ties the hands of the person who's hearing about your story and what happened to you. So for us, that's very concerning. Next page, please. Next change. So again, this is a bit of a weird one. Okay. This is specifically if you agree with your landlord that you will move out on the 30th of May or something like that, and then you change your mind. Your landlord can apply to the board and get an automatic eviction order without a hearing. This change to the act will take away. So what you could do then is if you get an automatic eviction order with no hearing, then you can file what's called a motion to set aside, which is a chance of a hearing, so that the board will look at all of your circumstances. So, I mean, the board still always has to look at all of the circumstances. Who are you? How long have you lived there? Do you have children? Are you unwell? Are you working? What's your income? What happens if you've been evicted? All kinds of things like that. So the landlord and tenant board has to look at all your circumstances, except in a case like this, it's saying that with the new Bill 60, the province is going to say what circumstances the landlord and tenant board will consider and produce some rules and guidelines on when that agreement to leave can be canceled and when it can't. So, for example, we've had situations where a landlord comes to a tenant and says, here's your eviction order, sign this paper and I'll give you an extra month. Or here's your eviction order, I'll give you a month's rent at the end of your tenancy, and has you sign a paper. If you sign that paper, which you certainly don't need to do, then they will get the automatic eviction order with nothing to do with the original notice or the original problem, just you agreed. So basically, my advice is never sign one of those unless, never agree to end your tenancy unless it's your idea, or you've got some legal advice and you understand that this is the best option for you because you're definitely going to be evicted. That's pretty rare, but occasionally it happens. So never sign an agreement and your tenancy unless it's your idea. And I'm speaking to tenants here. This will remove some of our ability as tenants and people working with tenants to say, hey, this is what happened. The fellow showed up at 10 o'clock at night, or the landlord showed up, she showed up at 10 o'clock at night, and I just put my kids to bed, and she said, I'm done with your fighting, and I'm done with your noise, and I'm done with your mess, and you didn't put your garbage in the garbage can, and your dog runs around, and sign here. And if you did sign here, this will take away some of your ability to explain why did you sign here. So, next page, please. We're almost done. So this is a bit of an odd one too. As I said before, we have this section of the Act, and you wouldn't be familiar with all the sections. We call it Section 83, and it basically says that the board has to look at all of your circumstances. They have to hear your story about why eviction is not the right thing for you, why you've changed your ways, your dog is no longer running wild, you can pay up your rent in a year, you can pay an extra $200 a month till it's all paid, or your circumstances have changed, or maybe the thing that you did wasn't so serious and you're going to make amends, you're going to do better. The board can look at you and your family and your circumstances, anything you want to tell them, and decide that it's not necessarily necessary to evict you. They can also postpone that eviction. So they can say, well, your kids are in school and we understand there's a lot of hardship. We're not going to ask you to leave. And maybe your landlord needs to move in there, but we're not going to ask you to leave till the end of June when your kids are finished school. Bill 6 is going to change the way that makes that decision a little bit. And they're gonna set rules about how long can eviction be postponed and under what conditions. And as I've said, for every single one of these, it's not the law yet and the regulations don't exist. And it's only for postponing eviction and not refusing. So we just don't know. But they're taking away, and every single one of these, they're taking away some of the power of the person who hears your case, the adjudicator or the member of the landlord and tenant board, to consider your personal circumstances and be fair and humane and decent. So again, it's possible that the regulations will be helpful to tenants. We don't know, but it's not likely. I got to be frank. Next page, please. Okay, so those are the amendments. There's only 8 amendments. It's not the end of the world. You still have a right to hearing. You still have a right to defend yourself. You usually will be able to catch up on rent that's owing. You'll usually be able to change your behavior. And the landlord and tenant board will still have to look at all of your circumstances before they decide that it's absolutely necessary to evict you. That hasn't changed. But how will this affect renters? You can turn the page, please. Yeah, this isn't too easy to read, but I'm going to give you a bit of a summary. It means, and if anybody is looking for a copy of this presentation, we can certainly make it available. It's not private; it's all public information. So as I said, a couple of things are changing. You're going to have less time to prevent eviction, particularly if it's because you're behind in your rent. You're going to have faster hearings and shorter appeal periods. So it's a fast tracking of a system that's actually pretty fast right now, at least for tenants. We'll talk in a minute about some of the other problems, but it's a fast tracking. And it's going to mean that tenants are going to be able to bring fewer defenses or fewer reasons why they shouldn't be evicted, whether it's because the landlord hasn't done repairs, whether they fell into a situation where they couldn't pay the rent and they fell much further behind paying for other expenses. Now, you're not going to lose your actual right to defend yourself. The majority of things that we will bring before the landlord tenant board are still going to be perfectly acceptable and perfectly reasonable. But it does mean that there's a chipping away of the ability of tenants to bring their cases and their answers and their to the landlord and tenant board, and a shortening of time to get those cases in front of the board and to get people evicted. So even the postponing of eviction, it's a bit of a fast tracking. It's worrisome. It means that in the future, once this becomes enforceable law, and it's really not yet, it means your hearing is going to come faster and your duty to get things evidence in, get organized is going to be tighter. Getting legal advice early, getting help is going to be more and more important. So that's the primary impact of these changes. It isn't clear to most of us how these changes are going to help landlords to build better housing and more affordable housing faster or better. We can all speculate about why the balance of justice is tipping it in this way. I won't be the one to speculate right now. Next page, please. So that's the end of my summary of the changes. Here's some basic information. Again, if you're not in our area, Lanark, Leeds, Grenville, North and Central Frontenac or Addington Highlands, then you need to contact your local community legal clinic. Easy to find if you look up community legal clinic online. If you want legal services from us, you need to phone us. That's the first stage, and press 0. Then you get to one of our very helpful intake staff who will give you some quick advice or information about what to expect. And a lawyer or paralegal will get back to you shortly. It's important not to contact me directly because you won't be on the list. But I am giving you my email address, not for the purposes of legal advice, as much as if you have questions or concerns, just of a general nature. Again, all our services are free, and our front office staff are fantastic at getting emergency cases to us right away. Even if the sheriff is coming tomorrow at 8 a.m., if you call me right now and press 0, okay, you don't press 0, you're not even going to get me, but press 0. Our support staff, helpful intake staff, will get you legal advice immediately within probably an hour or less. So that's the summary of the changes that are coming. I hope I haven't served to confuse you. I understand there may be some questions, so I'm open to any questions. Thank you.
Well, thanks so much, Linda. And again, we've done this before. With changes in Bill 60, it's so relevant to do it again and to ensure that people understand that, one, their responsibilities as tenants, but their rights. And together we faced numerous inquiries over the years. I still keep Linda's card handy all the time to make
Oh,
sure that
no.
everybody can speed dial when needed. Because the reality is there have been, sadly, I would say predatory landlords who have tried to evict people wrongfully. And Linda's been there countless times to ensure that people get the legal representation they need to try and make sure they can stay in their home. And we know, as I mentioned earlier, almost half of the people in Smith Falls rent their homes. We want to ensure that you have the ability to stay in your home if you want to stay in your home, if you're facing an eviction. We know that the most affordable home you have, the one you are in right now. And the risk of moving means a significantly higher cost of rent if you can find a place. And additionally, when you're paying much more money, much more of your income on rent, you have less money for other essentials. So critically important. And I think, like I said, probably at least a dozen times, if not more, through your presentation, call us. We're here to help. So a couple of questions. One just regarding leases. So I've heard in the past too that people sometimes get the misunderstanding that once your lease is up, you're at risk of eviction. Can you please clarify?
That's a great question. So the good news is that nothing changes once that 1 year, 2 year period of your lease ends. So the law says at the end of that initial term, whether it be, it's usually 1 year, you stay as a tenant on this with the same rent, the same rules, the same terms and conditions as we say. You stay as a tenant and you go month to month. But what that means is simply that you can stay of indefinitely unless you're evicted by the landlord and tenant board using that process: notice, application, hearing, eviction, and only the sheriff can remove you. So at the end of a lease, you stay as a tenant, same deal, same rent, subject to the once a year increase, and you don't lose any rights. And this Bill 60 originally said they were going to remove that right. I frankly don't believe they ever intended to do it. I think they kind of wanted to give us a big target to shoot at. And everyone started shooting, saying you can't do that. But they didn't take away your, what we call it, security of tenure, which is a legal term saying you have a right to stay indefinitely as long as you follow the rules, pay your rent, and you're not evicted. Doesn't matter that your lease is up. That's the long answer.
Perfect. Thank you.
Nothing changes.
Next one relates to cash for keys. And we've had other people approach me on this over the years. One particular building in town where a relatively new landlord has tried to move people out. Some have moved, some have stayed. Can you talk a little bit about the cash for keys situation?
Okay, so cash for keys is a slang, okay, for paying you money to leave. No, we're all free actors, and if we want to accept a check for $5,000 and give up our home, you as a tenant have a right to do that. But I always want to walk people through the math. So if your rent right now is $1,000 and you're moving into let's say a 2-bedroom apartment or even a 1-bedroom, your rent's probably going to go up to $1,800. If you're going to accept a cash for keys offer, which you don't have to accept, I mean, generally speaking, my advice is don't accept it. Okay. Because if your landlord gives you $5,000, $1,000, $5,000, $10,000, even $10,000, if I'm paying $800 more a month for the rest of my life, it's not going to last me more than about a year. And if I end up homeless because I agreed to leave at the end of June and then I didn't find anything, it's not going to last me very long in a motel, if I'm lucky enough to find a motel, which could be $100 to $200 a night, depending on the season. I'd be lucky to get something for that. $100 to $200 a night is at least $3,000 a month, and you get $10,000. You're going to be completely on the street after 3 months. So cash for keys offers. It's not illegal. It's not a bribe. It's not illegal for your landlord to make a free agreement with you to leave in exchange for a payment, but you do not have to agree to that. And you want to get legal advice before you sign anything agreeing to end your tenancy. And as I said with Bill 60, there's going to be changes that will affect your ability to get out of such a deal. Very hard to get out of those deals. So that's
Okay. Thank you. Another question. My landlord has given me a N1 form, and on it there's a 2.1% rent increase. Also, an added written line that says 1192 tax increase adjustment to 2026 mill rate. I'm not understanding what this is.
okay. I think this is mobile home park. I think it's a mobile home park because that doesn't. It's possible, or oh no, it could be no, it could be something else. So there are rules in the now this is a tricky one. Somebody's testing me here. There are rules in the Residential Tenancies Act about a rent increase above the 2.1% this year. Okay. And it could reflect an increase in taxes. But your landlord does not have an automatic right to that. This is definitely a question. If you get it, you need to call us. Okay. There are rules in the Residential Tenancies Act that the rent could go up by more, or it could go down. So if the landlord's taxes go down, they're supposed to reduce your rent, believe it or not. Okay. Interesting.
It is a mobile home park.
It's a mobile home park. Okay. Different answer then. Okay. The different answer is that in a mobile home park, there's two parts. It's different. You still have all the same rights in a mobile home park. Okay. All the same notices. There's a couple changes. And in a mobile home park, number one, you pay your rent, plus you pay your taxes on your mobile home alone. Okay. So you're paying property tax because you own the house. Okay. And the taxes are passed on to the tenant in most parks, but not all of them. Particularly, it's completely lawful, and you have a right to contact your municipality and ask, what is the tax on my specific property, on my specific mobile, not on the park, okay, not on the land, but on my home. And it's based on the value of your home. So if I have a mobile that's worth 25,000, I'm going to pay a certain amount. If I have a beautiful mobile home that's turned into quite the comfortable, luxurious place, and it's worth 100,000, then my taxes on that'll be higher. So that's what that is. So in a mobile home park, you usually pay a rent amount, which is fixed and governed by 2.1% or 2.5, whatever it is, plus your taxes are separate. Okay. And they are passed through the landlord. Yeah.
Okay. Next question relates to N13.
N13.
Someone gave a N13, and their landlord has suggested that they have to move out to allow for extensive renovations.
This is one of my favorite questions. And definitely come in and get legal advice right away. N13 for renovations are complicated. There are a lot of rules, and landlords have to follow all of them. They're very, very specific. They frequently are not successful. I'm not going to tell you all the rules, because this is not a training on how to evict tenants on an N13, okay? But an N13 is a notice that says they want to do renovations that are so very serious that they require a building permit and you cannot possibly live there during the renovations. So the majority of renovations, new kitchen, new bathroom, new flooring, new drywall, new windows and doors, if they're in the same place, okay, and they're the same size, don't require a building permit, and you don't have to move out for those renovations. So I strongly recommend that if you get an M13 for renovations, you get advice right away. Because the other good news is you have a right to move right back in at the very same rent just as soon as those renovations are done. Definitely need legal advice for this. At the same time, I think many of you will be aware that the town of Smith Falls is working very hard on what we call a renoviction bylaw to make sure that folks aren't cheating the system and evicting people unlawfully without permits, without appropriate processes, without work being done, and then not allowing tenants back in. That is happening still. It's happening in our community quite often. And my congratulations to Smith Falls, who has been acclaimed as the only small town in Ontario that's looking at doing this. Because it's mostly big cities like Toronto and Ottawa. Even Ottawa won't address a renovation problem. Anyway, long answer. If you got an N13, I know I keep saying this, get some legal advice. It's pretty technical, and I would say that over 90% of those notices will not succeed in eviction. Well over 90%. In fact, we're seeing that the vast majority of tenants who get notices will not be evicted if they get legal advice and go to their hearing. So
Excellent.
no guarantees, but that is definitely being our experience. Hope that helps.
Wonderful. So I have no further questions, I don't think.
Wow, we're so timely.
Yeah, and so Linda, I guess I'll give you an opportunity for a final word, but essentially, I guess the key thing today is the message I've heard so repeatedly. Call if you face an issue with your landlord, especially if you're facing any potential eviction, call 264-8888, hit 0, and you will get assistance.
Absolutely.
And, worst case scenario is they will tell you they can't help. It's a situation where it's fine, but in all cases where you need help, the help is there for you. Try to ensure you can stay in the home that you have enjoyed, hopefully for years and decades, and continue to do so. And Linda, the last words for you.
So just to summarize, I would say that the majority of rights of tenants are not going to be affected by this bill. There's no need to panic. It's a very technical change to your rights. All the basic rights, the right to defend yourself, the right to have a hearing, the right to get legal advice early, those things aren't changing. And the majority of tenants who respond to appropriately to a notice will not be evicted. And there's a lot we can do to also help people ensure that the place is repaired and it's safe. Mm-hmm. I thank you. I thank the town of Smith Falls, and I thank Mayor Panko for your open and cooperative approach to looking after our folks. And it's one of the things I love about living here.
Well, thanks again, Linda. And for those who are watching, this will be available on both Facebook and YouTube going forward for if you want to see it again. Anyway, thanks everyone for your participation today, and especially thank you, Linda, again, for being there to support our citizens. Have a great day, everyone.
Yes, thank you. Bye-bye.